Thank you. Welcome, everyone. We're going to be talking today about creative protection order remedies that holistically address victims' safety needs and cultural needs. And we thank you for joining us. I'm going to turn this over to Judge Collins to do introductions.
That's right. Welcome, everyone. Thanks for joining us today. I'm Judge Rosemary Collins. I'm a retired circuit court judge from the state of Illinois. I was on the bench for about 30 years when I retired not long ago. During that time, I started out as my career as a prosecutor and then as a defense attorney. And then when I got on the bench, eventually I was the presiding judge of our family division and then the presiding judge of our domestic violence division. In our domestic violence division, we combine both civil and criminal cases together so that we could do a more cohesive practice for our domestic violence practitioners and the participants. I also was the I was the coordinator of our domestic violence coordinated council for over 20 years, where we brought together police and prosecutors and advocates and lawyers, defense lawyers and treatment providers and culturally based community groups together regularly to talk about domestic violence issues and how we could change our practice for the better. Because of that, we were named as a mentor court by the Department of Justice. And so we were a mentor court and had the opportunity to learn a lot and be able to engage in some innovative practices on domestic violence work. I also have worked as a consultant with Professor Orloff for over the last 10 years on immigration issues. And I'm also a trainer on that too. So I'm really happy to be here with you today. Judge Maven, would you like to introduce yourself, please?
Certainly. Good afternoon, everyone. Thank you for joining us on this exciting topic today. I am Susan Maven, a retired judge from the Superior Court of New Jersey. I was on the court from 2001 to 2022, and over those 20 some odd years, I sat primarily in the family court doing domestic violence, matrimonial work, as well as juvenile work. I sat some time, 4 years, 5 years at the appellate division. So I was an appellate court judge until I decided to return to the trial court to take over the juvenile delinquency docket. While there, I was assigned to oversee the development of a pilot program for juvenile human trafficking diversion program for youth who were court involved. And through that, in my county of Atlantic and Cape May County, any youth who were court involved, who are at risk or involved in sex trafficking and human trafficking, were put through our program and allowed to receive additional services. After retiring, or even through that time, I worked with Professor Olaf to create the National Judicial Network, which we hear today, and Rosemary and I and several other judges around the country serve on the steering committee, where we help to produce the content that we produce on a monthly basis. Since retirement, I've been back on recall for a short time, and I finished that term, and now I'm back to private life doing my passion projects, which are human trafficking, domestic violence, as well as diversity, equity, and inclusion, and those types of work that we're doing through our court systems.
Thank you, Judge Maven. Let me tell you, Professor Orloff, you started the session, but would you be willing to introduce yourself and give us a little more information about you?
Sure. My name is Leslie Orloff. I direct the National Immigrant Women's Advocacy Project, American University Washington College of Law. Many of you know me more for my work involved with VAWA self-petitions, U visas, and T visas, and immigration relief for immigrant victims. But I actually started my career, spent the first 17 years of my career litigating domestic violence cases and protection order cases in particular. So this training is near and dear to my heart. And we're going to be talking today about many of the creative remedies, the creative approaches to working with immigrant crime victims, immigrant victims of domestic violence and child abuse in protection order case, and how important the protection orders are as a remedy for immigrant survivors. So I'm very excited to be here and happy to have all of you joining us. Back to you.
Thank you, Leslie. Now, our work is funded in part by the Office of Violence Against Women and the State Justice Institute, and for that we are very grateful. We also want to make sure you understand that any views expressed today do not necessarily represent the views of our official sponsors and the policies of either one of those institutions. I want to tell you about the National Judicial Network that Susan briefly mentioned. This is an exciting opportunity for those of you who aren't members yet. Judges, it's a group where we come together to talk about the issues of human trafficking and immigration. It is an amazing group of people. We're very widely based. We have 405 judges in 43 states and territories. But it's a great opportunity to get together and discuss issues that we care about with other like-minded judges and receive the latest information. You know, Leslie brings in experts from all over the country to answer questions we might have about very diverse set of issues. We get peer-to-peer training. We can receive a lot of information like bench cards, training materials. It's just a wonderful group, and I highly encourage you to join. And even better, it's free. So you don't have to pay anything to join. The little QR code there, you can point your camera at it and click on it. It'll take you right to it. But it's also going to be in the chat, the link to join it. So if you would like to join us, we'd love to have you join us. Our goal is, of course, to get somebody from every state. So if you know a judge in one of the states that's not a member yet, we'd love to have them join us. But Leslie, what about people who want to join a group like that but aren't judges?
Well, right. So in addition, so the QR code is for judges only. We have similar communities of practice, peer-to-peer learning opportunities that we encourage all of you to join. Daniela will put these links in the chat as well, so that when I switch slides, you'll still have them. We have one for family lawyers who represent immigrant victims. We have one for victim advocates. And we have one for law enforcement and prosecutors, and that one, systems-based victim advocates are welcome to join as well, who work for law enforcement and prosecution agencies. So I encourage all of you to think about not only coming to our webinars, but getting involved in these community of practices, because as participants in these community of practices, you can help drive the content and identify emerging issues that you'd like us to address in training. So we're going to start by having a poll as we all settle in here. I want to get a sense of who's on this webinar today. So if you could take a moment and check off whether you're a judge, an attorney, a victim advocate, whether you're court staff or a law enforcement or prosecutor. If you're other, please check F and type other in the chat, and we'll get to see who is who's on the call with us today. And I appreciate everybody sharing where you're coming from around the country. And as you're voting, as you're filling in this poll, I want to remind you that as we start presenting, we will be asking you to share your questions and comments in the chat. And I see that among the others, when you're ready, if you could share, Shannon, when you think, share the results. So we have about 1% are judges and 2% are court staff. We have attorneys, victim advocates, another 1% of law enforcement. And then people are typing in the chat. We've got magistrates, we've got therapists at rape crisis centers who are joining us, consultants on trauma, immigration case managers, a whole range of people who are here to join us on this webinar today. Judge Collins?
Well, let's talk about the learning objectives that we're going to go through here today. I mean, obviously, if there's grounds to issue an order of protection, then we want to make sure that we issue an effective one that protects the immigrant victims and their children. And along with that, along with these effective orders, we want to make sure that we order remedies that will actually interfere with the power and control being used by the perpetrator against the victim. We know that that we must address a victim's cultural, religious, immigration-related, financial, and other needs through creative protection order remedies, because you can do that And that's an important thing for survivors to have. And we also know the role that no unlawful contact protection orders will play for immigrant victims. So, Leslie, is there any research about abused immigrants seeking protection orders?
Yes, Judge. One of the things we found is that where courts are providing language access, where courts are providing signing U visa certifications, where courts are issuing SIJS findings, um, even in times of increased immigration enforcement, immigrant victims continue to get protection orders. And the key to that is the role that advocates and attorneys play as essentially a bridge or broker that encourages, so that when victims go to advocates and attorneys and are getting help from advocates and attorneys, immigrant victims are exponentially more likely to be willing to seek protection orders from state courts.
Okay.
Okay. So what we see is that when we look at some of the other research on protection orders, we find that immigrant survivors who are seeking protection orders have often suffered, by the time they get to a court, fairly high levels of physical and sexual abuse, of stalking, dating violence, and child abuse. Often the child's children, the survivor's children, have also been victims of abuse and stalking, sexual assault, abuse, battering, extreme cruelty. And what we find is that with support from advocates and attorneys, victims will use the protection order system, even though when they come to a program to seek help with domestic violence, almost 61% of them don't even know what a protection order is. But 81% of immigrant victims with safety planning and advocacy were willing to seek protection orders, particularly those who experience high levels of abuse. So we see evidence in the research that safety planning is working. And 96% of victims were willing to get protection orders. Immigrant victims were willing to get protection orders and found them helpful. Or of the ones that got them, 96 found them helpful. But they work best to control the physical abuse, and they help reduce physical and sexual abuse and ongoing incidents of abuse, but they don't work as effectively to control immigration-related abuse. Hold on one second. And this is the research I talked about before, that where courts are perceived as a safe place for immigrants to turn for help through language access, U visa certifications, SIJS findings, outreach to the community, and ruling against abusers who raise immigration status, let's say in family court issues, as a weapon. Those, even in increased times of immigration enforcement, immigrant victims do turn to the family courts for protection orders at relatively high levels.
So let's talk about some creative protection order remedies that are available. We all know about the regular remedies that we have, that we issue in every order, but there are some cases that need a little more creative work, just to make sure that we effectively offer relief for immigrant victims and some other victims too that need that kind of innovative relief. And our statutes all allow for it because there's a catch-all provision. And so what we really want to do, we want to curb future abuse and harassment. As I mentioned before, we want to interfere with the abuser's ability to exert power and control over their survivor. We want to help them leave an abusive situation if they wish to and when they wish to. We all know that survivors may have their own timetable, and so they may not want to leave on our timetable. But we need to understand that and make sure that we give them the tools they need when they do decide they want to leave. We want to offer a victim remedy for past abuse and relief from that. We want to make sure that the victim can start their new post life, whether they leave or not. they'll have a different life after they get the order of protection than they did before. We want to make sure they have the tools so that they can deal with the effects of the abuse that's happened in their life and go forward. Of course, it all has to be a nexus with the victimization. And we want to give the courts an opportunity to counter immigration related abuse, which is specific to our immigration victims. And we also want to make sure we order culturally helpful remedies for all of our cases, because it's really important that courts understand the different cultural groups that are in the community, what counseling might be available for people in those particular groups, and what other remedies might be of interest or of help to different people in different groups that we might not know about.
And what's interesting is the protection order case law on this use of the catch-all provisions in state protection orders. These are the factors that those cases have found that judges have broad flexibility when they're trying to accomplish these kinds of goals, to issue the kinds of remedies that will help in this case at this time before then, in a way that is culturally responsive and responsive to the needs of immigrant victims.
Mhm.
Judge Maven, was there anything you wanted to add here? You good?
Think you've covered it. At this point, we'll be getting into more information on culturally specific remedies. And also, just to keep in mind as we go forward, that the remedies that are provided in protection orders are not just for the victim survivor, but it could also then be for the children that are involved in the family unit. So when we speak about these creative protections, we want to think about not just the safety of the abused person, but the children that may be impacted as well. And we'll talk about that a little bit later as well.
Great.
So, and that's really what orders protections are all about. Is if we decide there are grounds to issue it, then we want it to do what we to effectively protect those who are involved with the order. And so, sometimes there are protection orders from victims that are not actually separating from their abusers. So, what I'd like to ask you is, when might a victim not separate from their abuser, and when they're seeking a protection order? So, this is a poll. If you just click in on the poll and tell us, why might victims that are not separating from their abuser seek a protection order?
Okay, great. So you can please choose, it's a multiple choice question, and tell us why you think a victim not separating from their abuser might seek a protection order, would benefit from the protection order. And while we're doing that, I just want to say, and Judge Collins, I know you've had this experience too. I started doing no unlawful contact protection orders in 1983 and did hundreds and hundreds of them. And I know, Judge Collins, you also had you've had lots of experience with them.
Yes, I have. And I first saw it when I was doing as part of our mentor court training. I went down to see a judge in Kentucky, Judge Bowles, and he was doing them there. And it was the first time that I had ever actually seen that utilized. So it was very interesting to me. And then, of course, we taking the best practices from other jurisdictions, we brought it home to our jurisdiction as well. And there's a lot of good reasons for it. And I think pretty soon we'll find out what our audience thinks.
Shannon, want to share the results?
Yeah, we still have some coming in, but I will share it now.
Okay.
Okay.
Yeah. These
So-
are all right on point. There's a really good, I've done a lot of training in Hawaii. In Hawaii, they have very limited housing options. And so in the orders of protection there, it's often not feasible to enter a stay away or move out order because there are no other places for people to live. And there's multi generations in housing. The housing is very expensive. Uh, I'd say aloha from Hawaii. I wish we were all there. But so there are different areas of the country that have different housing things. I think we've seen a lot of areas of the country have some really awful natural disasters recently, and the housing is just gone. So It doesn't mean that victims shouldn't be protected, but it means you have to look at creative orders so that you can do that. And maybe we can go on to the
Yeah.
next slide.
And let me just say that I
Sure.
want to highlight that 87% recognize economic challenges are a big part of this. And also waiting, so for immigrant survivors, waiting for legal work authorization at 61% recognizes one of the reasons for staying. Sometimes they're the only support somebody has is through an extended family. And these do, 52% of you recognize that these do function to help curb abuse, even though victims are still together.
And there's a question from Emily that I'd like to talk about. She says, does law enforcement actually enforce these? And that was a big issue in our community because when you start them, if you haven't done them, law enforcement doesn't know what to do with them. And they didn't really like them. But once you do, you have to have an education session with them and try to explain to them why you're doing it and what it is and how they can enforce it. Then they embrace them because it actually seemed to cut down on a lot of issues that came out. But you really have to do extensive training with your law enforcement because if
And
it's a no unlawful contact order and they just see that and they say, well, they're both can be in the house, I'm not going to do anything about it. So I really encourage you to work with your law enforcement authorities to do that training when you start this if you haven't started it yet.
And what I found has found effective over the years is many times. I mean, let's just do a quick raise your hands. How many of you have worked with victims who've gotten protection orders and experienced an incident of physical assault again after the protection order was issued? I'm sure there's going to be like millions of hands raised.
That's right.
I don't know where I see them though.
Yeah.
Yeah, people are putting their thumbs up. That works.
Mhm.
So that's the point. What we do with law enforcement on these is we explain to them that if there's been if they walk on the scene and they see evidence of another domestic violence incident, that's all they need to enforce the order. These are generally not, it's not like one's enforcing the stay away. There is no stay away. They're just enforcing the do not molest, assault, threaten, physically abuse in the future. And they can be enforced and are enforced in that way. And here's the data I wanted to mention about immigrant survivors is that these are really important for immigrant survivors because very few, like less than 33%, leave their abusers until they get work authorization in their immigration case. And it takes between 3 to 5 years if victims are willing to file. Like once they file, it's 3 to 5 years to get work authorization. So many will, because they can file confidentially, will file, get a protection order to keep them safe while they're together with the abuser and reduce the violence. So they're very, very helpful in that context. So the next question we have for you is another poll. Have you obtained or issued a protection order for victims who were not separating from their abusers? This multiple choice again, returned to live with their abusers after they were granted a protection order that included a stay away, or or were separated, served with a protection order, and returned to live with the abuser by the time they came to court on the protection order case. So why don't you fill that out? Okay, can you show us the response to the survey? Okay.
Okay.
So this is great. About 68% of you have had the situation where you serve the perpetrator, and then by the time you come to court for the protection order, they've already gotten back together. 75% of you have worked with victims who, after getting a protection order, return to live with the abuser. And 46% of you have, obtained protection orders, which is great news for people who were not separated. Okay.
Yeah, and I suspect that some of us have done all of the above, that they've all gone into our courtroom. And there are a lot of good reasons why people might do each and every one of these. So that's what we wanted to have you think about, because in a lot of places, this is a concept that they're not familiar with. And so we want people to be aware of the fact that you can issue these orders and that they may be the most appropriate for the safety of the survivor and for and for the children, which are often victims as well. So there are many good reasons. So we're going to go into that. In the next slide, it says, let me close that. There you go.
So what we found is, and I talked about this a little bit earlier, is that we did research among immigrant survivors who obtained protection orders, including no unlawful contact protection orders. And we found that these protection orders were effective in preventing or reducing recurrent physical and sexual abuse, including for full contact protection orders where victims continue to live with their abusers. So they are effective in reducing the violence. And it's very interesting. I had a client years ago, and we had a program called Hermanos Unidos, where immigrant victims who were our clients were met with each other and had a support group for each other. And one of the women explained, like when she was talking about what the protection order did for her, and she was talking about a no unlawful contact protection order, she said what happened is that the physical violence went down. And the way she described it to the other women, she said, he'd raise his hand to hit me, and I'd hold up my piece of paper and he wouldn't hit me. It would, change the balance of power in the relationship.
One of the questions that I saw was, can you define no unlawful contact? And so, of course, anything that is a violation of the law would fall in that thing. But we're going to talk a little later about how you can do your orders. And in that provision, or in that section, we'll talk about, being real clear in your order what is covered. So we will talk about that.
Right. And there's a comment here about the need for supportive services, and that's true. The victim advocates and attorneys play a very important role in connecting victims to supportive services. And what we're talking about here is how those supportive services can address cultural barriers, but we're also going to be talking here about how judges can play a role and how family lawyers can ask for culturally appropriate and immigration-related remedies that help the situation.
And it really does shift the balance of power in a relationship. When somebody has an order, a court order that says you may not do this, you may not do that, then they are the ones who can tell the abuser, if they're staying together, this is what the judge said. You can't do it. If you do it, then we will call the judge and see what happens, or I will call the police. So it does shift the balance of power, and it lets the abuser know that that somebody is watching this, and that they won't be able to engage in that behavior again without having some consequences. And it helps the victims begin their path towards separation, because a lot of times they may come to court to get an order of protection because some incident has propelled them forward. Something has really pushed them in that direction, but they may not be ready to leave yet. And so they might have to gather documents. They might have to gather their finances. They might have to contact relatives to see if they can move in with them. So this gives them the time to get ready so that they can actually leave the home if that's the path they do. And so it's Leslie, as a law professor, are you going to tell us about Dixon?
Yeah, I will. But
Okay.
before I do that, what I want to say is the other experience I've had, and a lot of lawyers around the country that are using these have had, is that the police response when you call and if you don't get the protection order, then the next call the police is just another police report that leads to potentially maybe she'll go get a protection order. But if you have a protection order and the police see evidence of violence occurring again in violation of the no unlawful contact protection order, there's much more, you get a better police response as an immigrant victim once you have the protection order. And US v. Dixon was a 1993 Supreme Court case that I guess you could say I caused. We had a series of no unlawful protection orders between my client and her abuser, and he violated it 19 times. And I brought a criminal contempt case against the abuser because this is before the Violence Against Women Act made protection orders enforceable. And I jailed him for 4 counts of criminal acts basically four counts of violating the protection order and jailed him for 660 days. And when the U.S. Attorney, Eric Holder, sought to bring assault with a deadly weapon charges against Mr. Dixon for the abuse of his spouse, or it was actually Foster. It was U.S. v. Foster, and Dixon was two cases. I represented the wife of Foster. When he brought charges against Foster, Foster said no, double jeopardy, and the Supreme Court said no. A victim can enforce a protection order without creating it double jeopardy in the criminal case and preventing the criminal case from going forward. So US v. Dixon, we have both the amicus brief and the decision, Supreme Court decision on the webpage for you to look at after the webinar. So what has been your experience, Judge Collins, with no unlawful contact protection orders?
So I've done them in court when, in mainly two instances, when, not two different cases, but two types of cases. When people come in and they may ask for it at the get-go. So they may come in and say, I want an order of protection because I don't want him hurting me, but I don't have anywhere to go and he doesn't have anywhere to go. So you do it at the original order. And then secondly, I've done it a lot when people come in and want to modify or drop their order of protection. And we'll talk about that in a little more detail, but a lot of times I have found that this no unlawful contact is something that the parties have never thought of. So when they want to drop an order of protection, if this is given to them as a possible remedy, they often go for that. So I have issued them in many cases. And once we got over the law enforcement hurdle, because they didn't know what to do with them, and once we did our training with them, then they did enforce them, and it worked pretty well.
Yeah, and we found, I did, as I said, hundreds of these, and they really did work well to kind of calm the violence. And most of the time what would happen, we'd come to court after we served the abuser, they'd be together and he says, I'm not going to hit her again, I'm sorry, I'll never do it again. And I'd say, make the promise to the judge.
Mm-hmm.
And we do consent protection orders where he was promising the judge that he's going to hit her again. And that also, has ramifications and can help. Okay.
Right.
I can speak on that from my perspective in New Jersey. I didn't have the experience necessarily to the extent that Judge Collins, you've had in entering them in Illinois or the judge in Kentucky. But the way I would see it more so were in domestic violence cases where the parties were leaning towards a matrimonial dissolution. So they would come in one would apply for the restraining order, the attorneys or the parties themselves would ask for what we call here civil restraints. So the restraining order matter, the domestic violence protection order is dismissed, but the civil restraints has a similar effect, but is not enforceable in the same way through the courts. But it has the similar restrictions. Oftentimes parties cannot afford to separate. They're going to go through a divorce and economic distribution, equitable distribution of their assets. But for the time being, they want to lower the temperature, or they have children in the home that they both co-parent and need to co-parent. So they'll enter civil restraint, which will be no violence, no further acts of domestic violence, sleep in separate rooms, different types of relief that can be ordered. So there's, between A and Z, there are different ways we can put restrictions in place to protect this, the relationship of the victim or as much as possible. So that's how we do it in New Jersey.
We could go back to the last slide just for a minute, please.
Sure.
So when a person comes in who wants to drop a protection order, first of all, I'd like you to ask for an ID, because we have had, and I've had in my courtroom where people come in and ask for an order of protection to be dropped, and they aren't the person who got the order of protection. They're the new girlfriend, a relative, somebody like that. So ask for identification. It doesn't have to be a driver's license. It can be just something. So unless you issued the order and know who the person is, I have had literally imposters come in and ask for orders of protection to be dropped.
Wow.
And then if they come in and want the order of protection to be dropped, you can ask that if you have advocates available, because they're so important to the effective operation of our courts, our advocates. And if you can ask for an advocate, if they get a chance to chat with the individual who wants to drop the order of protection, So you can find out if the abuser's sitting outside the courtroom and is threatening them, or, if they're doing it of their own free will. And then I think you should ask the person in front of you why they want the order dropped. And many times it can be because they need some help with childcare. They know that their abuser is telling them that they're in counseling now, so they're just fine, or they need financial help. And so then the no unlawful contact is good, then, because you can say, well, if everything is great, then fine, we'll do the no unlawful contact so you can live together, you can see each other, you can provide childcare, you can get the financial help you need. But if it goes back to the way it was before, then you have an enforceable court order that you can call the police on and get the help you need right away. So just go through a process with them, and it works pretty well.
Thank you. That's really helpful, Judge Collins. So now we're going to move on to kind of talking about other kinds of creative protection order remedies. Judge Maven and Judge Collins, what are some of the important issues that need to be addressed from a judicial perspective, or from your experience, to make protection orders effective? And for the lawyers on the call, on the webinar, it's really important for you to understand, kind of from a judge's perspective, what they've seen in their experience about what kind of protection orders are what needs to be done to be effective.
Well, as I mentioned earlier, you need to be really clear in your order about what you're actually ordering, particularly if you're doing a no unlawful contact. So you can say, this is what I'm ordering, and this is what it means. You can't do this, you can't do that, or whatever the relief requested is. But you can provide childcare. You must pay the bills. So you need to be clear and concise and use plain language. We lawyers like to talk in lawyer talk, and so that's not often as effective because people don't know what we're saying. So make sure that it's clear and concise. I often have perpetrators repeat back to me what they are supposed to do and what they're not supposed to do. Like if I order them to go to counseling, then they have to understand that. I'll give them a brochure on where they can get counseling. So be clear, concise, make sure they understand it. Don't just ask them, do you understand it? Because they'll say yes. It's kind of like when I go out of the doctor's office, they'll say, do you understand? I'm like, sure, but I don't. So be real clear in your order. And then I also recommend you do a compliance call, because if you're ordering, pardon me, if you're ordering somebody to do something like go to counseling, then you better bring them back and make sure they're actually going to counseling. And if you have a compliance call, then they know that you're interested in the order and that you expect it to be followed. And so they're more likely to comply with your order.
I would add to that what's said in the courtroom is not an order. It can be said, but the parties aren't going to remember it as what's said. It has to be in writing. So carefully reviewing the orders when they go from the bench to the parties, it's very important. The specificity, as Judge Collins said, is important. If you can put times in there for when they can pick up the children or drop off the children, or when they can come to the home to pick up their personal items if they are going to leave the home, that they must be with a police escort if they're going to come to the home to pick up their items. Whatever it is, be very specific about it. And with regard to language, the specificity and clarity of the language is so important because, again, not everybody speaks English as we may. And then even if you do speak English, just to be real clear, because there's different levels of sophistication or lack of sophistication, as the case may be. So very carefully review I know sometimes the docket is a big docket, and we try to move our docket along, but it is very important for the people who are in front of us at that moment to have clear direction, or else they'll just be there will be challenges with enforcement through the police department trying to understand what was meant, or motions to revise or clarify orders coming in later.
Anything? You ready for the next slide, or Judge Maven, is this you?
Yeah, it's Judge Maven.
So again, here we are just speaking about the issues that can certainly be included in your orders, the purpose of which, of course, we've reviewed before, but of course, safety is number one, it's paramount. The custody and care of children. In these orders, although there may be other proceedings that may come later with motion practice or with divorce filings or more intensive review of financials, to the extent that you can through your jurisdiction, order some at least form of custody, parenting time, and caring for the children. It's so important to do it at the outset, because if not, then caring for children certainly is one aspect of that leads to violations of orders. The conflicts of people wanting to see their children or not being allowed to see their children, or not knowing if they can create more conflict and more domestic incidents of conflict in the future. Again, the housing issue, we've discussed it, the stay in place orders, or even if there are going to be shared residences. I've done orders where people can live in the same home but over certain days. So on the weekends, perhaps one person moves out from Friday to Monday, and the other person can stay in the house primarily during the rest of the week. That sometimes happens if there's a child, or if there's a child or a supported person who has physical disabilities that has to stay in that house, but they need to share the responsibilities of caring for that person. Sometimes that's a consideration. We've spoken about financial support. If your court practices allows for interim orders that at least maintains the status quo for the payment of household bills, if they share the payment of household bills, then try to do that until the parties can file a more formal motion or get attorneys to assist them in more detailed financial filings. But if you can at least order that they continue to share the bills, or just designate who's going to pay what because of testimony that comes in as to who's been financially responsible to maintain that status quo, I would recommend, if you can do that, to try to do that, at least to hold something in place. And then, of course, we're going to talk in a few moments about recognizing the cultural, religious, and community supports that may be needed for this particular family. Many times there could be some cultural centers that may be supportive, churches or other religious institutions that can support the family, or at least be maintained for the children. And we'll talk a little bit about that in a moment. Again, here's where we want to take the time.
I went back.
Okay. Again, within the context of the hearing, as a judge, you want to hear from the parties as much as possible about any of these particular aspects that may impact the decision that you make, at least on this interim basis or within the protective order, so that it can be addressed. Are there any cultural or religious ceremonies that each of them practice that they want to continue to practice? What time are your services, or day of the week are the services? If you're talking about the children, are the children involved in any religious training classes that they should go to or continue to go to? Which parent will take them? Are the children old enough to do curbside pickup so that there's no contact between the parties? And of course, sporting events and educational activities for the children should be addressed, at least on a temporary basis, until maybe the parties are able, through advocates, to come up with a different arrangement. But at the time that they're before you, you have the authority in most courts to address all of these issues, to try to keep the parties as stable as possible until more work can be done to come up with a more permanent solution in the future.
And what's really interesting about what you're saying is that many of the statutes will list things like financial and other custody and things like that in the protection order statute. But where they don't, all of these can be ordered under the catch-all provision, so
Yeah.
that no court is limited and no lawyer should be limited in asking for the things that they need to do to keep the victim safe, hold the perpetrator accountable in the particular case before the court.
And you may just want to check to see if you would already know this, I'm sure, but in your jurisdiction, as in New Jersey, we have set timeframes within which restraining orders need to be decided because of the more urgency in the safety concerns that need to be addressed. If a person needs protection, they need protection now, or more sooner than later. However, there are some cases out there where judges have where the issuance of the restraining order is sometimes tied to underlying criminal charges that may be pending out of the same incident. And some judges I've seen in some of the opinions that I reviewed in preparation for today deferred the issuance of a restraining order until the resolution of a criminal case and kept adjourning months down the road. So while there may be a temporary order in effect, sometimes it's better to settle it uh, and not wait for the criminal case. And Judge Collins, I don't know if you or Professor Orloff, if you've had that experience as well.
We encourage people to go ahead with the order of protection despite what the criminal case is doing pending, because a violation of bond, if there is such a thing anymore, is handled differently than a violation of order of protection by the police department. So if you need the protection, I mean, this is exactly what you're talking about with safety considerations. If you need that safety consideration, then you need an order of protection. And the violation of bond issues can be determined in a criminal case, but you need that order of protection. So when you call, you can tell the police, I have a valid order of protection. That's what's happening. They'll come out right away.
And what's also important is the whole protection order system was designed to give the victim a remedy that they could control themselves and seek themselves independent of the criminal justice system. So it's really important that the victim be able to get that remedy. So we're now going to do another poll. Judge, back to you, Judge Maven, you're on mute.
Okay, so this poll is asking, as we talk now more about the cultural aspects, we're asking if any of you are familiar with the concept of cultural competency in the context of judicial decision making. So yes, no, or if you're not sure, there's an option for that as well. And we'll give you some time to enter
We're going to start doing these a little faster, Shannon, so we can stay on track time-wise.
And as we consider cultural competency in decision making, we're going to talk a moment about those decision points and how judicial decisions are made. Maybe speaking to the audience, it showed initially that we had only a few judges, but this area relates not only to judges, but also to the staff and to advocates and attorneys as well. And looking at the results, we're about evenly divided between some of you being, a third of you being familiar with the cultural competency context, some of you not being real familiar, and then some not sure. So about 2/3 of you will really hopefully be able to walk away from this session today with a little bit more information that may be helpful to you. And as you consult with your clients or assist persons who come to you for assistance, and certainly for judges. So I first want to talk about judicial discretion. And if you don't know, then I'm sure you do. Just read a few of your appellate cases and understand that in the context of family court judges and issuance of protection orders were given broad discretion based upon the evidence that's produced at the hearing. So what's very important to know here is that if you're representing a litigant on either side, the abuser or the person who's being victimized, it's important that you present as much information to the court as possible so that the court has enough information from the evidence that's presented to use their discretion to consider the factors, the risk factor for the victim's safety, the need for the protection order, and then ultimately the remedies that will be issued in the particular case. And I'm citing to New Jersey cases because that's my jurisdiction, but I'm pretty certain that there are similar kinds of reviews in each of the various states. And again, the appellate standard of review generally is to defer to family court judges. Again, that's where we see the people who are testifying. We can see their body language. We can see if the person is shaking and crying uncontrollably because they're standing so close to the person at the next table. The judge should make some very clear findings about what they observe in the court. So appellate courts can review, upon reading a transcript, can hear what the judge is saying about what they're observing in the court. So there's a great amount of deference to family court judges based upon what they see, hear, and the findings that they make on credibility of the evidence and of the testimony that's presented. Yeah. And again, this is pretty much stating the same. Again, especially with credibility determinations, because it's often a he said, she said, or she, he, whoever the parties are, there's going to be at least 3 different versions of what happens and the extent of what happens in any incident that's um, brought forward to the court, whether it's the number of times that the incident may have occurred, or there could have been acts of domestic violence or incidents, what other persons may have observed if there are witnesses. All of that needs to be clearly placed on the record and within your findings that you make so that the appellate court can review it. And after reviewing it, they may say we rest upon the observations and the credibility determinations made below.
So Judge Maven, how might a judge's personal views impact their exercise of judicial discretion in family court cases?
Well, I'm glad that you asked that question. A lot of it rests on what you know about yourself and your own perceptions, and what you also hear, again, from the courts, from what's presented in court. So most of you, or many of you may by now have heard the term implicit bias or explicit bias. And what that is, implicit bias refers to the attitudes and beliefs that a person may have within their own awareness and control, or not within your control. So implicit bias affects our understanding and actions and decision making on an unconscious, excuse me, my nose is itching, on an unconscious basis. Most of us are not aware of our implicit biases because it's just so inbred in our perceptions and our internal beliefs that if we're not aware of it, they can become prevalent and they can permeate our decision making, our thought processes. And that obviously then would impact how we interpret that and import that and implant that on our decisions. Now that's implicit bias when it's unconscious. Explicit bias, on the other hand, are when you become aware of what your biases are on a conscious level, and then you perhaps decide to act on them or not act on them. That's explicit bias. So it's important to understand that implicit biases can become explicit biases once you become familiar with what they are. And this occurs, again, when your prejudices or your belief systems that you possess are in your conscious mind. And even as you may be hearing a case and you're hearing what's being presented by the litigants before you, that something in your own knowledge, your own personal view, seeps into the decision that you make. And that's not to say it's necessarily a bad thing, because we all have our own personal experiences that we come to the bench with. But it's knowing what those perceptions might be, and either being able to control them, tamp them down, or understand how it works in the context of the parties in front of you. Now, if you're not aware of what your implicit biases are, then I invite you to take the self-assessment test that's been developed by Harvard University. It's called the Harvard Implicit Association Test. And it's being dropped in the chat right now, implicit.harvard.edu. And if you were just to go into your browser and put implicit bias test, it will come up because it's that widely known. And you do it in the privacy of your own chambers or home, and it just helps you become more informed about yourself and your own perceptions and what that might be. So now, how does that relate to cultural competency? Well, cultural competency is a set of skills and knowledge that can help you learn and reason and solve problems comfortably when you're presented with people who are before you from different cultures. And I have it right here. You can read it for yourself, but it's about a learning process of who's in your community and what those social processes are in that community that would help you to understand better those persons who may be coming before you. So becoming culturally competent is a lifelong learning process that results in developing knowledge, skills, and behaviors that help us work more effectively. And again, as we learn more about our communities, it also then will help us to develop the training, experience, and therefore enhance our exercise of discretion. Next. There are components to cultural competency. Again, the first is awareness of one's own cultural worldview. So again, understanding your community, understanding your own internal explicit and explicit biases, and being aware of yourself and what you know about your community and yourself is a starting point. Then, of course, we look at the attitude towards those cultural differences. If you have a perception or have had a perception of a particular culture, and through your own education or what you've learned from what's been presented to you by advocates in your court, that may change your perception of what you believe or what you think you believe about the cultural differences of the persons who appear before you. And of course, we talked about self-awareness of your own culture and where that fits in this United States, which is a melting pot of so many cultures. And lastly, the skill, which is dynamic. Your ability to understand culturally, to engage in trainings or workshops or seminars, and to be open to learning about the persons in your community will certainly help you as an attorney, as an advocate, as a life coach, or as a judge, as you're dealing with the persons who come to you for assistance. Now, as we're learning more about the persons who come before us, I have this slide that says, please don't make assumptions. Cultural assumptions can really lead us down a dangerous path of making assumptions that can be very harmful if we don't understand the individuals or the social mores, traditions, and cultures that come before us. And again, these presumptions, it says what are desirable, what's in human nature, what is a problem, what's possible in the society. These are all things that can be explored, not necessarily in court at that moment, but just as a part of your community, understanding the demographics that are in your jurisdiction. And that can be found in many different ways. Without necessarily doing external research on a case in front of you, just becoming more informed citizens. You can understand the demographics. You can understand the communities that are in, the diverse communities that are within your boundaries in your jurisdiction, and educate yourself on the customs, mores, and traditions. And particularly if there's an opportunity, because there may be events in your community to meet leaders in those communities and become better informed, I think that would help overall, just your better understanding of the persons that might come before you. Don't wait to be on the bench to be surprised or wait to be educated, because the risks of not addressing things in a way with the remedies that we'll speak about in a moment, in a restraining order or being culturally sensitive, can be detrimental to the impact that you have with the parties before you, and can certainly impact their trust and confidence in the court if it's not perceived that you understand them or that they can be understood. Okay.
So what's really important too is for the lawyers and advocates on the call, if you want to, for those of you that have tried to educate a judge about your client's needs that were culturally or religious based, would you like to share in the chat some of the things that you've done to be successful with that? That would be super helpful as we move on to the next question. So how do cultural assumptions and stereotypes impede survivor witnesses from receiving justice? Another poll, and you can, did you type this one up? Yeah, okay. Oops, no.
I'm sorry, Leslie, I didn't get this poll.
Yeah, this one was long, so.
But that's okay. I think that just reading it together, I think just reading it together, we can just read it for ourselves, and I'll just, all of the above, all of the above. And if anyone has had, as Leslie said, if anyone has had this experience, share it in the chat. I think it's important, although we can't speak to you directly, we may be able to have our assistants to read some of the responses, because I think what's important, especially if there's a person who appears before you, or if you're trying to assist, and you don't quite understand that if one of the examples could be if a person is separated from their spouse, that may have a negative impact on them as to how they're perceived back in their home country or within the community, within your community, if something were to happen like that.
So as we think about it, I mean, we all want to make sure that we as lawyers and judges and advocates, we don't miss important testimony or information. We don't misread the situation. We certainly don't want to offend. And there are, so there are lots of ways. So let's turn for a second and talk more about, let's look at some examples from the judges, Judge Collins and Judge Maven, of protection order remedies that you've issued that it specifically address religious or cultural needs.
Well, I know of a good judge in a different jurisdiction that had a large population that they practice voodoo, and so this judge wasn't really familiar with that. And it is a large religion, but it's not always common in every area of the United States. So remedies that were asked for was to ask the voodoo priestess in that community not to issue a curse or a hex or whatever they call it, and I'm not sure the correct word, on the other person. So that can be an instance where, I mean, obviously we don't have jurisdiction over a third party, but it can be that you say, do not go to this voodoo leader, priest or priestess, and ask for this sort of thing to be imposed. But that was an instance where it just wasn't a common remedy asked for. And so it was a very creative remedy for that judge to say, yes, I will order that you not do that.
And where you have communities that are where with religious restraints, if you will, or paternalistic communities, you may find that if it's a woman who is being abused in the relationship, that it may be very shameful for her to, because the family will look down on her, of course, and not support her, if she complains about the abuse, or if she, seeks help in that regard, or and then if the man in this particular instance is deemed to be the primary custodian of the children because of this situation, it can be very challenging. So your order can, if she has sought out a support system in that situation, put in certain provisions about when she will see the child, or when he would see the child, with supervisors perhaps, to ensure that one person doesn't elope away with the children, or take the child away and do those types of things. So whether it's issues regarding children, and particularly religious ceremonies, maybe alternating first or third Sunday, Saturday, Wednesday, whatever the special day is, that's your week to go to the service, and on the alternating week, the other person goes to the service. You can put those specifications in orders as well, just as an example of some things that I've done in some of my orders.
And so all of these are examples. I see more examples in the chat. We will collect everybody's examples, the ones we have and the ones you're adding now, and share them, do an update of some of our documents and share them around with everyone. So do please keep sharing these examples. But addressing, learning as a lawyer what the cultural issues are and how he might be manipulating cultural issues, or I had this case where, he was trying to destroy the last memento she had of sentimental value from our own country, and things like that you don't think about, as they're not on the standard list, but they're super important, again, in terms of the power and control and helping our immigrant clients.
Well, I also think the abuser may be trying to exert power and authority over the court as well, by perhaps assuming that the court doesn't know their social using traditions or cultures and things of that sort. So it's very important for the advocates or the attorneys or whomever is helping the victim to give the judge the information that they need, educate the judge about what is, or bring in witnesses. Again, in a couple of the cases that I reviewed in preparation, the findings were made about the witnesses who were brought forward, the leader or the religious leader who challenged, who was able to testify that contrary to what the husband was saying, disciplining the children was not part of the tradition of their culture, the way that the gentleman was trying to say, well, yes, I slap my children, give them this type of discipline because that's part of the culture. And the religious leaders and a couple of other people who testified said that's not part of what we do. But if there's not that contrary testimony presented, then what's the judge to know? It's going to be one person's word against the other.
And
But the
that's,
weight of the evidence led the judge to be able to determine that that type of corporal punishment on the children was abusive and is not part of a tradition.
right. And that kind of cultural defense, there's a lot of in this where you can think about how do you get the evidence before the judge. Expert witnesses can be useful, and that expert could be somebody in the community that works for a nonprofit organization that has expertise in that particular cultural community. So it's important as lawyers to think about how we do that. We are going to launch in for the next kind of 20 minutes. We're going to talk about more about custody, economic relief, immigration, how to deal with immigration-related abuses, where we're going to be moving next. So, Judge Collins, why is it best practices for a judge to address custody and visitation in protection orders?
Well, we know that one of the big, obviously, when safety is a factor and children are involved, we know that if you don't make provisions for visitation and custody, then you are not really doing an effective order to protect the safety of anyone. And it's not right to tell a survivor that comes into court to get an order of protection that now you have to go to this court, and now you have to go to this court, and now you have to go to that court, because they aren't going to be able to do it a lot of times, and they can't get the relief they need as quickly as they need it. And so we can take measures. I'm not saying you have to do a full-on divorce case in an order of protection, but we can take measures and we can issue orders that deal with these issues so that the safety and well-being of the children are protected. And that's what we need to do. We know that one of the major reasons people go back, even if it's a violent situation, is because they don't have the financial resources to survive. And rather than be homeless or have their children taken away from them because they can't provide a place to live, they'll go back, and so then everybody's at risk. So it's really important for judges to look at it holistically and to issue the orders that we can do when we can do it. Immigration status is relevant to custody in a lot of ways, and it's not relevant if, I'm saying I'm a better parent because I am a native U.S. citizen, because that makes no sense. I mean, I know that many people who aren't Native American citizens are wonderful caretakers, but it can be relevant if I come in as an immigrant victim and say, they will not file, or they're going to withdraw my immigration request, then that's an evidence of abuse in and of itself. If they make threats to turn in a victim for deportation, it's part of their history of violence, because we know that if you want to get status for your wife or your husband and you are not a violent or an abuser, then you start the process immediately when you can, because it's not a quick process and you want to get working on it right away. But if they wait really long and they aren't doing it at all, then that's kind of a sign that they're not using it, that they're using the immigration as a tool. The best interests of children are not determined because who is a citizen and who isn't. It's determined on other things, and the requirements of awarding custody should go to a non-abusive parent. If you have found there's an abusive parent, then you should look at that when you're awarding custody. Your visitation orders and custody orders should include, who's got vacation time and when is it. Be specific, as we have said. If you get a vacation over spring break, then say when the spring break is. Birthdays are always a problem. So if somebody wants a birthday celebration, then you have to figure that out. Graduations, family events, all these things are important to the parties, and it's important that you deal with them in your order. Oftentimes, if you ask the parties how they feel about this, they will come up with an idea. So they may say, well, the graduation is held in this location, and there's a right side to the gym and a left side, or whatever. So the parties may be able to give you a solution that you wouldn't be able to come up with, and they may not. But it's always important to ask the parties if they have anything they'd like to tell you about this, so you can bring that in. Birthdays, we sometimes do birthdays at our supervised visitation centers, so that if an abuser wants to be with their child for a birthday, we can say you can have an hour at the the visitation center, and we will let them celebrate a birthday there. So there are ways to do it, but it does take time. You're going to have to take a little time.
Mhm. And I'll just say that this is an opportunity to ask again about religious ceremonies, cultural events, things like that, where it could cause problems if you don't address it in the order. So, affirmatively as a judge or as a lawyer, ask about these things so that they get addressed and they don't become areas of conflict in the future. Um, Protection orders can also be used to deter parental kidnapping. Judges can order not to remove the child from the court's jurisdiction or to turn over passports of the parties or the children so they can't flee the country with the children. You can ask to sign a statement that no visa or passport should be issued to the child absent court order, as a way of notifying the embassy that the abuse is occurring and that the judge is making findings about that. So there's lots of kind of creative things you can do to try to deter the parental kidnapping. And so
I have parties come in sometime and they say, you can't give custody to this immigrant because they will flee with the child. Is there any research on who is likely to flee with a child?
Yes, the State Department did research a number of years ago, and they found that the people most likely to flee with children internationally are people who can legally travel in and out of the United States. So dual nationals, citizens from other countries that can go back and forth, people who have work visas to be here. It is not undocumented immigrants, and it's not people that don't have a means to legally come and go freely from the United States. And we have the custody bench card that we have for judges, which we'll make sure we share on this page. If you could my staff will make a note of that. We'll add it to the page. Has the social science data on that. So Judge Collins, as we move on to another topic, what kinds of economic relief can judges issue in protection orders that help, as Judge Mabel was talking about earlier, maintain the status quo?
Well, in the theme of creative remedies, some of the things you can do is order registration for sports and things like that. These sporting teams that kids want to be on, they can really be expensive. And so you can order things like you have to pay the registration for the softball league or the baseball league. You have to pay for, whatever kind of sporting event that they're involved in. You have to buy the shoes and the equipment that they need. You can ask for the normal relief, obviously, for child support and spousal support. That's really important. Payment of medical bills is really important. But, think about things that really make a difference in the life of the children and the parent. And so if they've broken the cell phone, that people do a lot in these situations, have them pay for a new cell phone. Have them give over the identification cards and their information that an immigrant might need for going ahead with the process. So they might need passports. They might need a marriage certificate. They might need letters from them. They might need pictures, things that show that this is a valid marriage. So look for creative remedies, and again, ask the parties, because if there's something a party needs that you might not think of, if you ask them and say, well, I really need our marriage certificates, or I need the birth certificates so the children, then order them to be turned over.
I just want to add as well, we understand that much of what's on this list may require documentation to be presented that may not come to court on the day that the restraining order is really being heard. They may anecdotally say, well, you know, he pays all the bills, or he pays the rent, he pays the mortgage, and the judge will ask, well, how much is the rent? It's, you know, $900 a month. They may not have the receipts to show it, but so there's some temporary relief that can be put in place. And then you could say, you know, if you have your court, if there's other court staff, we keep forms in the courtroom, and we always have another staff member in the courtroom that could walk that person right down to the other department to fill out the application and, you know, give them more information to the next judge, or come back with the details about the extent of the bills and things of that sort. But as we had said earlier, you may not be able to address all of the financial issues, but you may be able to address some issues that'll hold them over for a month or two, or for whatever cycle it takes to have more in-depth applications made through the court, so that all of these can be done. Or if a divorce complaint is going to be filed, or some other kind of relief might be requested that may require some more documentation, at least there's something on your order that tells them to pay the next, you know, continue paying the rent for the next 3 months, or something of that sort.
And what's interesting about that is Judge Collins was talking earlier about status calls, because you could also, I had many cases where the judge would say, you're supposed to turn over X, the passport, the love letters, whatever it is that you need to turn over. You could have a status call by which the victim comes in and reports, did she get it or not? So that you're keeping pressure on the perpetrator to actually do what you've ordered, is one of the things. So there's also tax-related remedies that are super important for all victims, including immigrant victims. So, you know, that they turn over income tax statements, that they, you know, pay the victim half of the refund, that the victim is named as trustee for receipt of the tax refunds, that the victim gets to exclusive right to claim the children and tax deductions, all of these kinds of tax exemptions, all of these kinds of things can be super helpful. And I've actually had cases where you ordered him to turn over the check and sign it and turn it over to her in court.
Leslie, if I could just answer, Laura wrote a question about support. And Laura, Leslie has some great materials about affidavits of support, because if it's an immigrant family, there's a legally enforceable contract for support outside of any state law. And so I would encourage you to go on the website and get the information about affidavits of support.
Right. And I think what we'll do, since we're getting close to the end, we'll just say that these protection order remedies are particularly important for victims who have to wait for work authorization to really think about the economic remedies, so that they can have health care, they can have support, they get their affidavit of support enforced while they're waiting. Judge Maven, have you crafted protection order remedies? Can you tell us just very briefly, because we have about 10 minutes to go, about remedies where you crafted remedies where they were working for, the family was working for the same employer or shared a family business?
Yes, oftentimes, and this has happened more in the context of a domestic violence case that leads into a divorce case, where the parties have a family business. They own the community store, and if they are a particular culture, they are the center of the community, because they have the store, they have whatever the business is, and so their income is generated by both parties. You know, one's not working, the other is working. One keeps the books, and one does whatever they do. So in that regard, yes, I required in some instances that the books are held by an objective person, so that there's not one person controlling the recording of the income and the monies that come in and go out. I've ordered that they be in that store or in that facility at different times, so that there's not the conflict of being in the business, arguing and taking their personal business, you know, arguing in their business about their personal situation. So I have absolutely done that when there's a family business or a shared family business. And of course, the equitable distribution, New Jersey equitable, or the division of that comes later in a divorce, but they still have to get to that point of assessing the business and doing the distribution at the time of divorce. So I've done it, absolutely.
Wonderful. So I'm going to move on to the next part, where we're going to talk about protection order remedies that are particularly helpful for immigrant survivors. Judges, and this first one a judge in DC Superior Court started ordering in 1983. We've had judges all over the country order that defendants have to obtain, like the perpetrator has to obtain prior court approval before contacting any government agency, whether it be immigration officials, CPS, IRS, welfare, about the victim, except a police emergency or when there's a subpoena. Perpetrators have been ordered to cooperate in and not withdraw the victim's immigration case. I personally did criminal contempt cases and jailed somewhere around 10 perpetrators for violating this provision. Abusers can be ordered to sign a FOIA request to obtain information about the abusers or the victim's immigration case file that might be useful. They can be ordered to turn over evidence of that is needed for the victim's immigration case that may be in the abuser's control. While I'm showing you, maybe some of you can type some examples of what some of that kind of evidence might be that would be useful that judges should order. But it can include passports, birth certificates, work authorizations, green cards, copies of green cards, copies of all these, obviously, immigration papers, social security number, and then when the abusers destroy the papers, he can be ordered to pay what it costs to replace it, and make those payments and come back to the court to show that those steps have been taken. There are certain documents that are helpful for the victim to prove or attain legal immigration status, and this is a list for that. Border crossing cards, social security numbers, real IDs, state issued IDs, driver's licenses, ATM cards, lots of things that can be useful for the victim to sustain herself and the children and to potentially help with the victim's immigration case. Health insurance cards are particularly important because many immigrants don't qualify even to purchase healthcare on the exchange until they reach a certain point in their immigration case. And we have lots of materials on when healthcare exchange purchases, when they can purchase insurance on the exchange through our public benefits map. But some of the things that a victim will typically need will be wedding pictures, family pictures, marriage certificates, love letters, tax returns, children's school records. And these are the kinds of things that judges typically can order turned over in a protection order case so that the victim can use those in their immigration case. And so, Judge Collins, turning back to you about some of the remedies that help with perpetrator accountability. Is this me? Judge Collins, you're on mute.
Sorry, my dogs were barking. So as we've said before, you have to issue detailed, comprehensive orders. Make sure they're really clearly set out. And if you have special conditions, put them in your order. Compliance calls are really important because otherwise you have no idea if anybody's following your orders. And we always put the onus on the perpetrator, so they have to bring in proof that they're going to counseling. They have to bring proof that they've turned over the firearm. If a survivor wants to come in, they're welcome to, but we try not to make it up to the survivor to do these sorts of things. And if a spouse comes in or a victim comes in and wants to have the order lifted, which has happened to me, they'll say, I want it lifted because he's in counseling now. And you find out he's gone to one class. And so you can say, well, you know what, let's just table this issue for now. And you come back in a month when you've gone to 3 more classes, and then we'll see if you feel that way then. So you can put that carrot out there that you will lift this portion of the order if they do the conditions that they're supposed to do in a timely fashion. So that's a good way to do that.
So I'm going to skip ahead and then back to this question. So Judge Collins, can you talk about best practices and orders in protection order cases?
It's really important that we put the basic facts in, like these people were married and they, what their relationship is. So not just that, not just that they have a relationship for the order of protection, but say they were married and where they were married if you can. And put the relationship of the child in there. This is their stepchild. This is their natural born child. This is, whatever it is. Make sure that you put in the incidences of abuse, detail them out so that if it's that there was physical or sexual abuse, say there was sexual abuse and that he raped her on this date or he did this. If there's abuse of the child, spell it out because that child may be able to go to court and get immigration relief based upon the abuse that they suffered. So make sure you spell out all the details. And if you have to give the order to somebody else to write up and then come back to it, do that, because it's important that you get all the details in there, not just a basic thing that I found that they are grounds to issue the order of protection. Put out exactly what those grounds are.
And it's interesting. I mean, there are a lot of different creative ways to address protection order needs. I once had a judge in a civil or criminal contempt case order the abuser. He basically talked with the abuser, and the abuser said his favorite thing to do is to play soccer every Saturday or Sunday. And this abuser, he had violated, it was a criminal contempt case, he violated the protection order. And so the judge ordered him to jail for 6 months every Friday night, and he couldn't come out until Monday morning. And he missed all his soccer games. And when he got out of jail and he served his time on that protection order, he, as a result of violence, he never went near his wife again because he didn't want to miss his soccer games. So you can think creatively about how you can use culture to hold offenders accountable as well.
I just want to quickly,
Yeah.
I'm sorry, I want to quickly add to Judge Collins. Again, I mentioned that I was on the appellate bench, so I'm used to reading transcripts. And if you haven't had the opportunity to do so, just Google, do LexisNexis, look up your state, put in domestic violence restraining orders, and read some appellate cases. And you will see how the appellate courts review the findings that the trial court makes below. And so it's very important that your findings be placed on the record or in your written order, however you're going to do it, so that you understand how extensive your findings have to be for credibility and the weight that you give the testimony and the evidence that's presented. That's very important to uphold and sustain your decisions.
That's great. So thank you, Judge Maven, and thank you, Judge Collins. We have resources for all of you. We're coming out with a new tool by the end of the year on a state-by-state tool on how you can use protection orders at your state level to help victims of human trafficking. We have demographics, we have census information that you can look up. We encourage you to call us for technical assistance and training, training that we can bring to your jurisdictions on these issues. Do not hesitate to contact us. And please do fill out the evaluation and let us know what you thought of this webinar. So I want to thank you very much. I want to thank our hosts at NCZA FCJ, Shannon, for doing a great job. And thank you, Judge Collins and Judge Maven, for sharing your time and your expertise with us today. And thank you for all the great work you're all doing out in the field. And again, contact us for technical assistance if you're working with an immigrant survivor and need help on protection order issues, family court issues, immigration issues, public benefits issues, language access, or any other issues related. Thank you so much for the work you're doing to support survivors every day.
And thank you, Professor.
Thank you.
Thank you.